little bit.
Yeah.
All right. Okay. We're at 1:30. So I think we can start with if there's no objection. All right.
I would object, but I'd be outvoted. It wouldn't matter.
You're gonna, but for the record.
Okay.
All right. It is 1:30. We have one case here on our docket today for 1:30, 21-29-55, Kidwell versus Olympus Insurance. My name is Judge Eric Eisnagel. On the panel today, we have Judge Jay Cohen and Judge Molly Nardella. And with that, we will get right into argument. Counsel for the appellant, if you'll let me know how much time you'd like in rebuttal, I'll try to remind you when we get there.
5 minutes, Judge.
5 minutes, okay. All right, you watch it, but I'll try to help you out there. And you can start whenever you're ready.
Thank you. May it please the court, my name is Chad Barr, and I have the privilege of representing the Kidwell Group, LLC, doing business as air quality assessors. And the assignor in this case is Maria Amadio. We're here today asking the court to reverse the trial court's final order of dismissal in this case for two reasons. The first reason is the trial court impermissibly decided an issue of fact at the motion to dismiss stage. And second is the trial court improperly retroactively applied 627.7152 to the facts of this case, or the assignment of benefits.
On that issue, really what you're going to be talking about is whether the total care decision was properly decided.
That is part of my argument, yes, Judge, as it relates to the second issue. The first issue is relatively simple, and I don't think I need to spend a lot of time on it. I did not spend a lot of time on it in the brief, but essentially, the defendant in this case, in response to the complaint, filed a motion to dismiss, and they allege that the assignment of benefits is actually an assignment agreement under 627.7152, and that the assignment agreement did not comply with the requirements of that particular statute. We did file a response, and at the hearing, we did raise an issue with respect to whether or not the defense was raised. So the legal defense with regard to the assignment agreement is whether they're standing to bring the lawsuit, and the response being whether or not there was a waiver of the defense by virtue of a payment before a suit was filed. So a partial payment being made before a suit was filed. In our complaint, we never alleged that what type of payment was made. It was actually quite ambiguous as to whether the payment was no payment or partial payment. Certainly the defendant knew that it made a payment in this particular case. And when we raised the issue at the hearing that there was a payment made and that could potentially result in a waiver of their standing argument, the trial court didn't even address it. There was no argument made in response to that by the
Mr. Barr, can I ask a question about your waiver argument? When it comes to as a matter of law, is there a factual scenario where you can waive the requirement of the statute, which says an assignment agreement that does not comply with this subsection is invalid and unenforceable? What would you point us to? How would you distinguish this? Or is this indistinguishable from waiver for, say, like conditions precedent?
That's exactly what it is. It's a condition precedent. You have to comply with the statute in order to have standing to bring a lawsuit for these benefits. And what their argument is that you don't have standing to bring this lawsuit. You didn't comply with the conditions precedent. You didn't comply with 627.7152. So they're raising an affirmative defense of you didn't comply with the conditions precedent. So
but isn't the subsection I just read, isn't that more than a condition precedent to bringing suit? Isn't that, go ahead.
Absolutely not.
Why not?
Because it's saying what you have to do in order to have standing, in order for you to have an enforceable document. And in order to have standing in this case, the assignment agreement has to be valid. And if it's not valid, then there is no standing. There's not a single case that the appellee in this case cited to that stands for the proposition that you cannot waive the issue of standing. And so that's what this all comes down to. The conditions precedent.
Is there anything in the initial brief that establishes that a partial payment is, as a matter of law, always a waiver?
I don't think that, no, we didn't put anything that says that it's always waiver. But that's a question of fact based on the circumstances of the case. So the standard of waiver is the knowing relinquishment of a known right. And so in this particular case, if they received the assignment of benefits and the assignment of benefits didn't comply with the statute, and they knew that, and they made a payment anyway, then that is the waiver argument.
Okay, but all we have is that in your brief, all we have is that they made a partial payment. There's really not a lot of other substance in your brief in the argument to even evaluate this waiver argument you're making. And there's no case that I can see that says that it's, as a matter of law, a waiver.
Well, we wouldn't know it's a matter of law because we would have to get to the summary judgment stage, because we would have to be able to develop the facts. I don't think anyone here would disagree that if they got the assignment of benefits and they looked at it and they said, this doesn't comply, but we're going to pay anyway, that is potentially a waiver. And so the question is it potentially a waiver? Not, is it a waiver as a matter of law, because we're here on a motion to dismiss. We can get to the as a matter of law when we're dealing with the summary judgment phase, but we're here, and certainly waiver is a reply in essence to an affirmative defense of lack of standing or no standing.
Okay, what other than just the conclusory statement that there was a partial payment and therefore that is a waiver, what other facts are argued in the brief to establish error?
There are no other facts, Judge, because we essentially had a complaint and we had a motion to dismiss. The defendant's argument is I just can't wrap my head around it, because what they're saying is we should be allowed to raise an affirmative defense. And because your response to our motion to dismiss takes us outside of the complaint, you should not be able to raise any issues in any factual issues in response to our motion to dismiss, basically saying we should be allowed to raise an affirmative defense in a motion, and you are not allowed to raise a reply to it. And so what we have in this case is we have the allegation that there was a payment made in response to the initial claim submission. The defendant did not dispute that fact below, and that the defendant did not dispute that fact in its answer brief. So I'm not saying that it's conclusively established. I wouldn't go that far, but it's certainly not disputed that there was a payment made. So I think that
don't you need to argue that as a matter of law, if there's a partial payment, then as a matter of, because you haven't provided us with any other facts from which to evaluate your argument. So don't you necessarily have to argue that a partial payment is, as a matter of law, a waiver of this standing argument, of the standing defense?
Well, we argued in our brief that waiver is a response to a lack of standing affirmative defense, which is essentially what the motion to dismiss was based on an affirmative defense. So I'm not quite sure how I could have argued any more beyond just the fact that waiver is an avoidance of the lack of standing affirmative defense, and that's what we have in this case.
Well, just facts to establish that it was an actual waiver.
Well,
what do you have to establish? What do you have to allege to establish a waiver? That
there was a knowing relinquishment of a known right, and
do we have enough here in the initial brief to even make that conclusion?
We have a motion, we have a case that's being decided on a motion to dismiss when there's an allegation that there was a payment made, and that payment is potentially a waiver. This is a motion to dismiss. I just don't see anything in the law that requires us to go much farther than simply saying that there is a factual issue here that the court cannot adjudge.
But counsel, that's my point. Your argument is that every partial payment is as a matter of law, is a knowing waiver. That's essentially your argument, right?
That's not my argument. That's not my argument at all. My argument is that in this case, the payment is potentially a waiver of their standing affirmative defense. I can't argue beyond this case because I don't have the facts of every case. I'm arguing in this case that they made a payment after they got the assignment of benefits that they allege is invalid. So therefore, they've potentially waived their lack of standing affirmative defense in this particular case. So I can't argue beyond this particular case. Turning to the second issue, essentially, I believe that the the fourth district in the total care case did not give the Menendez case due respect. And I think what we have to look at is we have to look at the parameters of 6277152 or the effect of 6277152 to see exactly how it affects the actual insurance contract itself. There are various things within the statute.
Does the insurance contract address assignment of benefits?
I have no idea. I don't know because the insurance policy is not in the record, excuse me. And so we're dealing with a situation where
But
we're
there's
kind
no
of guessing.
dispute factually that the assignment itself occurred after the passage of that statute.
The assignment occurred after the passage of the statute by about 4 months, I believe.
Okay.
And so we look at in figuring out whether Menendez applies and how it applies. I think we have to look at the statute, and there are.
But I'm struggling with the idea. We don't. There's nothing to establish that that the contract even address the issue. How can, and your argument is, well, the contract for insurance trumps the statute for the assignment of benefits.
My argument, I think, is more so that, and I could be saying the same thing you are, so I apologize if I sound like I'm disagreeing, but essentially my argument is that the requirements in 6277152 cannot be applied to or cannot change the requirements that are in the insurance policy.
Oh, but we don't know that it did.
We don't know that it did, and we didn't have that. We didn't have that opportunity. We didn't have a.
Let's say for the council. Let's say for the moment that the policy even says. I mean, just for the sake of argument, let's assume that the policy says that the insured has the right to assign the policy, to anyone, and that there can be, unfettered. How does your client have standing to enforce that right? I certainly can see how the insured would have standing to make that argument. But how does your client have standing to make that argument when the assignment that your client when your client attempted to step into the shoes, right, did so in at a time when 627.70152 was in effect. So in other words, your client, the statute we're looking at the assignment to see if your client successfully stepped into the shoes, right? So in other words, it's different. The insured may well have an argument, but how does your client have an argument?
Well, I think we have to consider the law of assignability. We step into the shoes of the insured.
Not according to 627.70152, right?
Well, at the time the policy was issued, we stepped into the shoes of the insured.
No, but you stepped in after 627. You attempted to step in. The question here is, did you step in, right? That's the question.
Okay, fair enough.
Do you agree with that? That's what we're trying to figure out.
Okay. Go ahead with your question. I want to answer your question.
So at the time that your client attempted to step into the shoes, either successfully or unsuccessfully, the statute was in effect.
Correct.
So why did that not control your client's attempt to step into the shoes?
Because we have to look at this statute as a whole and see how it affects the insurance policy itself. So for instance, subsection 2A contains all of these things that are required in order for a homeowner to assign their benefits to a service provider. So we've got all these requirements in 2A. 2C. 2C is important because what 2C does of the statute is 2C actually restricts what portion of benefits the insured can assign to a service provider. So it limits the scope of benefits that can be assigned in certain circumstances. So Judge Eisenagel, you wake up in the middle of the night and water is shooting out of the hose going to your washing machine. It's a relevant example for me because it recently happened. And you immediately call an emergency service provider. This statute limits how much of those benefits available under your policy you can assign to a service provider. It limits it right there to $3,000 or 1%.
Counsel, I think the problem here is that where I'm struggling is what you're saying sounds like a very strong argument for the insured to make.
Well, but it continues on. So not only that, but then it requires there to be appraisal under the policy. So the appraisal has to be done by the service provider. So we don't know if the policy has an appraisal clause in it, but even if it doesn't, 627-71522E requires the service provider to go to appraisal under the policy. It also goes and it changes the point at which the insurer's liability attaches under 7B of the statute. And it specifically says that any contracted work performed before the assignment agreement is rescinded is due to be paid by the insurer. So we have to look at this as a whole, and I have a hard time understanding how we look at this statute and say that we have to parse out the insured versus the service provider when the insured stands in the shoes of the insured for all purposes. And we have a situation where, and it goes on, it also affects and it shifts the balance of attorney's fees as well, from what it used to be under 627-428, and now puts the service provider in a position where they potentially owe fees. And I think if we look at Menendez and the issues that Menendez had with the statute, with the pre-suit notice requirements and the PIP statute, they line up almost perfectly with the concerns that we have with respect to this particular statute. I see I only have 4 minutes left, cutting into my rebuttal time, and I'll reserve the rest of my time for rebuttal.
Thank you, counsel. Okay, counsel for the appellee, whenever you're ready.
Thank you, Your Honor. May it please the court. I'm Kim Fernandez, representing the appellee of Olympus Insurance Company in this case. I have 3 points to make. There are no factual disputes precluding the dismissal that happened below. This case is not about the retroactive application of section 627-7152. And to Judge Cohen's point, the issues that are raised in this appeal regarding retroactivity have been resolved by the 4th District Court of Appeal when that issue is pending in all but one of the district courts in the state of Florida.
Counsel, jumping ahead to sort of the last issue or one of the last issues, would you agree that the attorney's fees, would you agree that's substantive?
Not all attorney fees issues are substantive. The entitlement to attorney fees still exists. Entitlement versus non-entitlement would be substantive. Yes, the method.
But it seems like a very different entitlement, right? The change. I mean, so is your position is that's procedurals? The attorney fee, the sort of the right to fees.
The right to fees. The right to attorney fees.
Right.
Those 3 words or 4 words. Right to attorney fees.
The statute changes at the 57-105, right? Is that right?
Correct.
Yeah. So in your view, that's not a substantive change?
It's not a question of whether that is a substantive change that matters at this point, because subsection 10 of the statute has been parsed out in other case law with regard to attorney fee provisions and the retroactive nature of attorney fee provisions. This particular case talks about the building blocks upon which the contract itself for the vendor needs to apply, needs to meet in order to even be eligible and have standing to come to the court.
Right. The hoops you have to jump through to have a valid assignment might be procedural, and I assume your argument is that it is procedural. But I'm asking on the attorney fee change, is that also procedural or is that more substantive?
My argument is that it's procedural because it exists. The entitlement to attorney's fees did exist and still exists. But most importantly, it does not exist until that vendor is a party. And that vendor doesn't become a party for purposes of even making an argument, making an assertion for attorney's fees until their AOB contract is executed and perfected under the statute. This is a case that was properly decided below based on the parameters of the 4 corners of the complaint itself and its exhibits. There was no stepping outside of those documents when the judge made the decision for dismissal. For instance, this talk of a payment that was made. Any party challenging a summary judgment can raise a factual issue such as a payment was made, and that is a waiver of the argument. First and foremost, I need to tell you that if this case were to be remanded and were to go through more discovery and we were to get to an MSJ standard, the evidence would show that no payment was ever made. There was an error made in asserting that a payment was made by plaintiff's counsel below, and no payment was ever made. But even those last three sentences I gave you stepped outside of the four corners of the complaint itself, which do not establish standing for pursuing entitlements to anything under the assignment of benefits contract.
Counsel, let me ask you a question. When I spoke to Mr. Barr about this, his position was that the AOB statute is basically a condition precedent, which has to be complied with in order to bring suit. Do you agree with that interpretation of subsection D, 2D that I read, which requires that the assignment agreement comply or else it's invalid or unenforceable? It doesn't say if you comply, you bring suit. It just says there is no agreement if you don't comply. How do you view that? What is your response?
Correct. That subsection 2D, Your Honor, makes it void ab initio if it doesn't meet the standard. It's not an affirmative defense, and it's not a condition precedent to bringing forth the defenses or the arguments that plaintiff's counsel made below in order to avoid summary, in order to avoid dismissal. You can't come to the party without an invitation, and the invitation has to have several boxes checked off. And in this particular case, at least 5 of those boxes were not checked under the enumerated requirements in subsection 2A of the
So
statute.
is it your position, your client's position, that there is no factual scenario, zero factual scenario, which could exist, which would waive standing, basically, which would waive subsection D, your ability to dismiss the complaint because they failed to comply with the statute? Is there any factual scenario which could exist if this case were remanded?
No, Your Honor, my position would be no. And it's all because of subsection 2.
Okay.
That there would be no waiver, because there has to be compliance with subsection 2 in order to have a voice in asking for something under a policy. Excuse me.
Counsel, you could go through the entirety of trial, not contesting the validity of the assignment, and after judgment, then say, hey, this whole thing is void. I mean, at some point, haven't you waived it?
Well, it seems to me that after judgment, yes,
Okay.
it would have been waived. But
How about in the middle of trial? Could you change your mind and say, hey, wait a minute, we don't think the statute was complied with?
standing is a fatal issue to a complaint, to bringing forth a complaint. And so, yes, no, it would not be waived at that point. And yes, it could be raised because standing is always a valid argument to make. And that's why.
I mean, so your position is it can't be waived as a matter of law.
Correct.
Okay.
What I said to begin with was that the statute is building blocks for creating an assignment of benefits. If you don't have the building block, you don't have an assignment of benefits at all. I'm not going to get into the waiver argument because, again, it goes beyond the four corners, and I don't want to go too far beyond that. I just want to point out that with regard to I don't think the court has any issue with the fact that the 4th TCA has already decided the retroactive portion of the argument being made, but I will speak to it. I wish that I could just read to you the total care decision because it has a lot of good points in it about.
Counsel, we've read the total care decision.
Okay.
What's your view on ProCraft?
Oh, wait. If you want to read it to us, though, you can do that, but we'd like it to be a dramatic reading.
I've seen those on YouTube.
And then after you do that, counsel, maybe you could talk to us about ProCraft.
Sure, with all due respect, on the ProCraft case. ProCraft it deals with only subsection 10 of the statute, and it involves AOB contracts that were executed prior to the enactment of the statute. That's not the case here. We have a statute that was enacted, and then we have an AOB contract that was created and executed.
I've read a lot of cases, so I could be misremembering, but I thought ProCraft was the one, the middle district case where the assignment was after the effective date. Am I just misremembering that?
I'm not sure, Judge. I have 4 cases listed with a note on my notes indicating that all 4 cases dealt with AOB contracts that were executed before the enactment of the statute.
All right, I'll check it. I'm talking about the Procraft versus Metropolitan Casualty.
That's the citation that I was referring to
Okay.
as well, Your Honor.
Perhaps I'm misremembering. Go ahead.
So we're not going to address in the retroactivity because this court is well aware of it. Menendez began to be mentioned by opposing counsel on its application. And I must resist the application of Menendez in this case, basically because it has to do with motor vehicle no fault law, which is very different than what we're dealing with here in this case. And so there has been an effort to apply the Menendez decision to the first party property new AOB law time and again, nearly in every appeal that's gone up on this particular issue. But when a PIP law addresses a grand bargain of trading no fault recovery in place of common law tort litigation, that's so very different than first party property that doesn't have the same goal of swiftly and virtually automatically putting benefits in the hands of an injured person who needs medical attention. Very different than having a property damage as opposed to someone in dire straits because of a physical injury. And just for that public policy reason and that explanation of the reason behind the Menendez case and the PIP statute, so very different from the first party property statute that it should not be found to be applicable to an analysis of 627-7152 in this particular case. There has been statements made in the past, particularly by this court actually, that wouldn't it be helpful if we had the policy to review? Wouldn't it be helpful if we had the invoices to review to understand the application of the statute to Kidwell as a party and the services that they're providing? And that answer is similar to the waiver. The answer that I have for the waiver, that this all would go beyond the 4 corners of the documents that we are allowed to review for dismissal. And the particular documents that are allowable to review for dismissal in this case provide all that is needed to find for dismissal due to non-compliance with 627-7152. Specifically, there was no rescission provision in the policy, in the AOB pursuant to subsection 2A2. There was no 3-day provision for providing the contract to the insurer, subsection 2A3. There was no written estimate included with the AOB contract pursuant to subsection 2A4. There was no required notice statement in a certain font, all caps, to be included in the contract pursuant to 2A6. And there was no indemnification clause for a protection that is required by the statute pursuant to 2A7. These are all protections that were written in to protect the consumer. So the fact that a contract is executed after that statute is enacted and they do not include the protections for the consumer is important to note. The intent, it appears that the intent was to write the AOB contract around the statute so that the statute would not apply to it by virtue of including language from the statute into the AOB contract. For instance, by stating this document is not meant to protect, repair, restore, or replace damaged property. The same contract that indicates it's writing itself around the law by not doing those things also provides an explanation, though, for the services that will be provided by this vendor in its contract, which show that those services do meet the terms of the statute. The contract specifically says that the services to be provided by the appellant are to determine repairability of the property, to determine the scope of damages on the property, and to prepare a report for prescribing or confirming proper remediation procedures. Those types of services actually will meet the statutory provision to show that they do intend to lead to repair, restore, replace, and replacing the damaged property. I'm looking for the complaint itself. Yes, the complaint itself also states, and this is in the record at page 8, I believe. page 8, that in exchange for an assignment of benefits, the plaintiff provided assessment services to the insured directly related to the loss in order to repair or replace damaged physical property. All of this shows that the efforts of the plaintiff meet the application of 627-7152 in this case.
Counsel, I know that argument has been made in other cases. I'm not sure that's the feature of the case today. But let me go back to Procraft. I think Procraft is the case I was recalling. The court in that case concluded the effective date of the statute is May 24th, 2019. And then in a footnote, the court noted that the assignment in that case was entered into on June 5th, 2019. So nevertheless, the court in Procraft looked at the underlying policy date as opposed to the assignment date. I think I was trying to read it again here during argument, so I might have missed something, but so I just wanted to give you an opportunity to address Procraft, assuming that I am reading it correctly now.
Okay, I might have lost you on some of the dates, but
in other words, the court in that case opined the effective date being in May and that the assignment was entered into in June.
Okay.
So the assignment would have been after the effective date, according to the Procraft court. But nevertheless, Procraft looked to the date of the policy. And so I just, I didn't know if you wanted to address that or not.
Okay, I appreciate that. And Procraft, of course, looked to the date of the policy, which our argument would be the date of the policy doesn't matter, because all that matters is what brings the Kidwell Group, the plaintiff, to the table, which would be the assignment contract, not the policy contract itself. The policy contract, of course, gives an insured, a homeowner, rights, but the assignee, Kidwell, did not get there and get any rights until they signed a contract. And so the contract date signed by Kidwell on the AOB would be controlling. In that particular case, based on the facts, although they may have had the start date wrong on the May start date of the statute versus July start date of the statute.
I'm not saying they're right about that. I'm just saying that was the conclusion that Procraft reached. And so it necessarily had to look at the policy date instead of the assignment date.
It seems that it also means that they had the policy and policy date to look at in order to make their analysis. Whereas in this case, on the dismissal, we only have the complaint and the exhibits, which would be the AOB contract itself. And the policy does not come into play. And that's okay, based on the argument that I provided, that it is the AOB contract date which controls and not the policy date which controls.
Would this case be different if instead of the assignee as a party, it was the insured?
I'm not sure. I'm not sure of the point being made, because there wouldn't be an AOB contract if this was the insured coming forward.
Well, I mean, could the insured challenge the retroactive application if there was, say, a provision in the policy permitting unfettered assignment? And now you have 627-70152 saying, no, you have to jump through all these hoops to have an effective assignment.
Okay, sorry, Your Honor, I'm getting lost in the hypothetical for a moment.
Well, you agree that the insured would have standing, at least.
The policy provides the insured with standing.
And so if the insured had some argument that the statute here changed the policy, then that would be a different case altogether, would it not?
It would be a different case, because the insured could always raise an issue with regard to the policy as a contract if they believe it's been breached in some manner.
Or changed retroactively, right?
Trying to apply a retroactive statute. Yes, they would have standing to make such an argument.
Right.
Yes.
Right. I'm not saying that they would have merit. I'm asking that, but they would have standing to bring the challenge, right?
Correct. And to your point, that is where the analysis for today stops. Is there standing to make the argument? Not, but is there a good reason for not following that argument? You have to get to the court to even make a statement first. And lack of standing doesn't give you the ability to go forward and make your claim to the court. It's where it stops. If there are no other questions, I will cede the rest of my time.
Thank you, counsel. All right, counsel, for the appellant, you have about 4.5 minutes. You're free to proceed whenever you're ready.
Thank you. I just want to address a couple of things that were troubling to me in the answer brief, and they're still troubling to me now, hearing them come out of opposing counsel's mouth. It's that the fact of the payment, we raised the payment, and she's saying the fact that there was a payment is outside of the scope of the complaint. Well, again, our position is we did plead that there was either no payment or a partial payment. But beyond that, it clearly makes the point that I was trying to make earlier, which is that they're raising
counsel, just one moment, just so I'm clear. You didn't plead it, right? You just said it at the hearing.
Well, I would argue that our complaint alleges that not all benefits were paid. So that could be interpreted as no payment was made or a partial payment was made. It doesn't say that there was a partial or no payment. It doesn't say either way.
Okay.
But beyond that, my point is that we raised it at the hearing, but what she's saying is we shouldn't be able to present it at all, and they should win simply because they filed a motion to dismiss. And if the court considers anything in opposition to the motion to dismiss that goes beyond the four corners of the complaint, then it shouldn't be considered. And I just don't understand that at all, how that gets to where we're trying cases on the merits instead of technicalities, because then why wouldn't every insurance company file a motion to dismiss, raise an affirmative defense, and then argue, well, you can't assert any facts in response to this because they go outside the four corners of the complaint, when it very well could be that the reply, in essence, does require us to raise facts that go beyond the four corners of the complaint. But if we follow Ms. Fernandez's analysis, we'd never be able to do that, and we would lose every motion to dismiss hearing. And I don't think the law is set up that way, and I certainly don't think that gets us to trying cases on the merits. I think that is ambushing. I think that's trial by ambush, and I don't think that's what this court would ever allow to happen. The other issue.
You agree, though, that the avoidance has to be adequately pled, right?
If we're raising it as an actual reply, yes. If we're raising it to present an issue of fact, an issue of fact at the motion to dismiss stage, we don't have to plead it. We just have to raise it. It just has to be in the record.
Do you have a case for that proposition? I mean, it seems like your argument is a lot stronger if you, I mean, it seems like if at the hearing you essentially stated all of the facts as you would plead them, you would have a stronger argument anyway. Do you agree?
Your question asked me to assume that I know what they're going to raise as an affirmative defense, and that I have to, in my assumption, raise those issues in my complaint in order to be able to avoid their motion to dismiss. It's absurdity, because if I have to plead my response to their motion to dismiss, then I have to anticipate their motion to dismiss, their argument, and I have to go ahead and put it into my complaint.
No, I mean, I'm asking you at the hearing, the facts and argument that you sort of alleged on waiver at the hearing. Did you have an obligation to put the court on notice of a full avoidance? An adequate.
What is an adequate? I don't know what an adequate avoidance is in response to a motion to dismiss. Okay. We told the court that there's a question of fact as to whether there's a waiver issue, and the court didn't even bat an eye. Went right into, I've ruled on this issue before. I already know the arguments. She didn't even consider it. The transcript is clear that the hearing lasted 2.5 minutes. I mean, it just doesn't make any sense. And then with respect to the insurance policy, again, this is, in my opinion, straight gamesmanship, because what's happening is Ms. Fernandez is arguing that we can't consider these arguments because the policy is not in the record. That's their burden to do that. And could the court have even considered it if they did put it into the record, because it's outside of the four corners of the complaint? So there's way too much at stake here, and there's way too much unanswered questions here for the trial court to have dismissed this case at the motion to dismiss stage. So for the reasons that we've argued here and the reasons in our brief, we would ask the court to reverse the final order of dismissal. Thank you.
Thank you, counsel. And with that, we are adjourned.
Thank you.
Thank you. Have a good day.
Thank you.